Good evening, my lord. I'm Ellis and I appear on behalf of the pursuer, Hardware and Surfaces Limited. This is a debate in the case of Hardware and Surfaces Limited against Primemacadam Limited. This is an action in respect of payment arising from contractual terms. I would ask my lord to have in front of him the record, list of productions, the Rule 22 note and the authorities that I will be referring to today. Has my lord had a chance to read the record? At the end of my submissions, my lord, I'm going to ask you to sustain the pursuer's first plea in law in the principal action for a decree to the sum of £39,600 sterling with interest from the date of citation to follow, and to find the defenders liable in expenses and repel the defender's plea in law. The pursuers rely on their first plea in law in the principal action in respect that the defenders admit that they are due the liquid sums to the pursuers in relation to the parties' contracts for the supply of asphalt to various locations on various dates, where there are no averments that the pursuers were in breach of those contracts. The defenders seek to retain payment of those amounts pending the determination of their counterclaim. They cannot relevantly do so, as the supplies relate to separate contracts, and decree should be pronounced for the admitted balance due to and proof to be set for the defence's counterclaim. In summary of our case, on the 17th of June 2018, the defenders ordered asphaltic road surface material from the pursuers. The pursuers in turn accepted their order, and delivery of the material was made to a site being operated by the defence. The invoice for this is dated the 18th of June 2018 and can be found at 511 of process. The invoice clearly states that payment is due within 30 days of the invoice. The defenders then made a further 11 orders from the pursuers dating from the 20th of June 2018 to the 26th of November 2018, which you can see from the list of productions in front of you. Each of which were accepted by the pursuers, and delivery of the material was made to the different sites operated by the defenders. And invoices for each individual order were sent to the defence, all stating at the bottom clearly that payment is to be made within 30 days of receipt of the invoice. The sum of the invoices issued by the pursuers to the defenders is £43,200. All of these said invoices fell due for payment within 30 days of issue to the defenders. Demand has been made to the defenders to make payment, but they have refused or at least delayed to do so. My lord, there are 12 invoices in total, and this amounts to the sum of £43,200. And 11 of these invoices are not in dispute, totalling £39,600. The disputed invoice can be found at 5111 of process, dated the 26th of November 2018, and has a value of £3,600. My lord, I'm going to deal with the issues in relation to liquid and illiquid debts and retention of payment. The legal issue in this case is that the defenders are not entitled to withhold payment in respect of all of the contracts because of an alleged breach of one contract. The principal action for payment is not irrelevant, nor is it lacking in specification, as the defence has admitted that they are due liquid sums to the pursuers in relation to the parties' contracts for the supply of asphalt. The defence have made no averments that the pursuers were in breach of 11 of the 12 contracts, and therefore the sum sued for is not excessive, as is the contractual amount for the undisputed contracts. My lord, the defence is seeking to offset payment for each of the contracts which they held with the pursuers, not just one which is in dispute. However, the pursuers are entitled to payment in full of all of the completed and satisfied contracts totalling the liquid sum. The defence are entitled to withhold payment of the single disputed contract until further investigation and evidence. And the law states that the defence cannot offset payment for completed contracts against the illiquid sum pending further action in court. My lord, I'd like to refer you to McBride and what he states in the Law of Contract in Scotland, 3rd edition, at 14 to 63. It states that damages are illiquid were sought following a breach of contract, and these damages cannot be a counterclaim in an action for a contracted price, and does not offer a defence to a claim for outstanding sums under a contract. Therefore, in the present case, the defence is irrelevant and payment for the undisputed contracts cannot be withheld. In the case of Purac Limited against Bizac Limited, 2005, reported in the Scots Law Times at 37, there are two companies who entered into a construction consortium agreement for the construction under a separate contract of a wastewater treatment centre for a third company. The agreement provided that Bizac Limited was the lead contractor and were obligated to pay Purac Limited any monies due to them within 5 days of receipt of the monies from the third company. The defence here had withheld payment from the pursuers, and the pursuers in turn raised an action against them seeking payment in respect of the work carried out by them. The defence argued that they could retain the sum due as a result of a defective performance from the pursuers. It was held that in this case there was a single contract between the parties, and Lord Drummond Young stated that the defence did have a right of retention as they met the 4 requirements for this right. Firstly, the right can only arise where the obligations are interdependent or counterparts of each other. In the case of Purac against Bizac, the obligations of both parties were interlinked, as the company hired the defence under a separate contract to construct the water treatment centre. The defence then contracted with the pursuers to carry out the work for this purpose. The defence would pay the pursuer for their works under the contract within 5 days of receiving the monies from the external company. The second requirement is that one party must be in material breach of the contract. And thirdly, the function of the right of retention is to provide a party to a contract security for performance by the other party of its outstanding obligations. If a party is deprived of its substantial benefits of the contract, then they can be seen to have the right of retention. And lastly, the right of retention can be found in any contract if all of the requirements are fulfilled, even in building contracts, where they're mutual obligations. Here, the defence had a relevant defence for retention, as the parties had a mutual obligation to fulfil, and where one is breached, the other would fall through. The case, however, required to establish proof to explore the claims on which the retention was based. In the present case, the defence has not yet met these 4 requirements in retention for all of the contracts, and therefore it cannot be established that the right of retention based on the common law from Purac against Bizac. In 11 of those contracts between the parties, there had been no material breach in the contract, and therefore there is no basis for retention of payment. In the case of Barton Distilling Scotland Limited against Barton Brands Limited, 1993, reported under Scots Law Times at 1261, the two companies had contracted for the supply of whisky, where the defenders agreed to purchase a large quantity of whisky with the intent to sell it on. The dispute arose as the suppliers had breached that contract by failing to supply that whisky, causing the defence loss of profit, which they then went on to counterclaim for. It was agreed in this case that the principal action was for a liquid claim and that the counterclaim was illiquid and required proof. The pursuers argued that the defence were not entitled to retain the sum sued for by showing that various contracts formed a course of dealing. Then argued that unless there was a presence of a single contract or a series of transactions which could be deemed as part of a single contract to the extent that there was true mutuality between the parties in respect of all matters arising in that series of transactions, a plea in retention in respect of an illiquid claim cannot be upheld against a claim for a liquid debt. The defence argued that there were 4 exceptions to the general rule against the plea of retention. Firstly, where the illiquid claim admitted of instant verification. Secondly, where both of the liquid and illiquid claim arose out of a mutual contract. Thirdly, where one or other of the parties was bankrupt. And lastly, where in exceptional circumstances, retention was allowed to meet justice or convenience of the particular case. In this case, Lord Osborne held that the first exception of instant verification could not be invoked, as there was a need for A, proof of a failure to supply the whisky, and B, proof of the market value of the whisky before the counterclaim could be determined. He then held that although the principle of mutuality could be extended to apply to 2 or more separate contracts where the parties agreed to do so, there were insufficient averments on record to establish that the supplies on the different occasions had any agreed quality of mutuality. And lastly, it was held that in the case involving 2 commercial entities, there was nothing to justify the court exercising its equitable discretion and decree de plano granted in the principal action and proof before answer allowed in respect of the counterclaim. Therefore, when applied to the present case, it can be shown that the defence is entitled to retain the sum only of the disputed contract pending the investigation and determination of their counterclaim for damages due to the alleged breach. This is due to the fact that there is no instant verification of the breach. Secondly, in this case, there had been no indication of a degree of mutuality between the parties in respect of the various contracts. All of the contracts were independent of each other. In the case of Inverness Public Limited Company against Tullis Russell Papermakers Limited 2010, reported under the UK Supreme Court at 19, the defence entered into an asset purchase agreement and a separate service agreement with the pursuers for the purchase of property rights to a brand. The agreement provided for various payments to be made to the pursuers, the first being a payment of initial consideration, which was duly paid by the defence. The defence then declined to pay any further payments and argued that no sum was payable until procedures for determining the sum was due was set out in the asset purchase agreement. It was also argued that the pursuers had breached their obligations under both agreements. As a result, the defence were entitled to retain payment pending the determination of their claim for damages against them. The Supreme Court held in this case that retention is possible where 2 contracts are seen to be part of one transaction. However, in turn, in the present case, all of the contracts are not part of the same transaction, but rather each are separate, and therefore the defence is not entitled to retain payment for all of the contracts by offsetting liquid sums pending the determination of the illiquid counterclaim. My Lord, in conclusion of my submissions to the defender's averments in answer should be seen as irrelevant, as the pursuers have supplied the material as per the contractual terms for each individual contract and have not received payment. The defenders have failed to make payment within the 30-day period as stated in the contractual terms between the parties and have no basis to withhold such payment for the undisputed contracts. At common law, the defence have no entitlement to withhold payment for any undisputed contracts due to one disputed contract resultant from an alleged breach by the pursuers. I would ask my Lord to uphold the pursuer's first plea in law in the principal action for decree of the sum of £39,600, with interest from the date of citation to follow, and to find the defenders liable in expenses and repel the defenders' first all pleas in law. I also invite my Lord to fix proof for the counterclaim of the defence arising from the one disputed contract found under 5.1.11 of process, which is the invoice dated the 26th of November 2018. This disputed contract is for the sum of £3,600 and requires investigation and determination of their counterclaim for damages due to the alleged breach. Thank you, my Lord. This now concludes my submissions.